And next, we'd like to turn your attention to veterinary malpractice. I put this in our slides because it comes up a lot, and it probably because my practice is in an urban area, I see a lot of companion animal issues, and a big part of that is veterinary actions. And most veterinarians are great, and they love animals, and it's not an issue. It's only when something happens and the matters can't be resolved by the parties themselves, and it goes to court. But this photo is one that I took actually in Chicago. I know it's a little hard to see, but if you look closely, it's a photo that says from the AVMA, or American Vet Medical Association, that states, "We are your other family doctor." Many people are surprised to learn that the official position of the AVMA is that pets are merely property, despite this advertising that recognizes that they are, in fact, the other family doctor, clearly recognizing animals are part of our family. And I mention this because it came as quite a shock to me that certain veterinarians held this view that animals, really should not be ascribed any value beyond fair market or something like that. And I reference a case that we had that occurred from an incident in December 5th, 2010, when Michael and Heather Mangarelli had brought their 2 Pomeranian dogs, Dolce and Lindsay, to a holiday open house hosted by their veterinarian at the Orchard Road Animal Hospital out in Montgomery, Illinois. There, the Mangarellis had hoped to have Dolce and Lindsay photographed with Santa Paws for $10, as had been advertised in the Orchard Road event prior to the scheduled holiday open house. However, as the Mangarellis entered the first set of doors to the veterinary clinic, a large 150-pound mastiff barreled through the second set of doors that had separated the Orchard Road lobby from the entry vestibule and grasped the Mangarellis' 5-pound dog Dolce in its mouth. A large pool of blood resulted, and unfortunately, the mastiff had lacerated Dolce's artery, and the Orchard Road veterinarians were not able to save Dolce. Not surprisingly, the Mangarellis brought suit against the owner of the large mastiff and the veterinary hospital because the veterinary hospital had not placed any restrictions on the 2,000 people it had invited to the event. There was nothing in the public banner that would say not to bring dangerous dogs or dogs that had aggressive tendencies, or even that dogs were required to be in any more docile form to be part of that event. Also, there was really nothing in place that protected the Mangarellis from what occurred. The case did settle prior to trial for a combined amount of $19,000 for the negligent acts of both the animal owner and Orchard Road Animal Hospital. But what was interesting is the attempt to devalue the Mangarellis' dog by one of the veterinarians who claimed to perform the emergency procedures on Dolce after the fatal attack. He testified that companion animals were in fact mere property and that his services were akin to oil changes in a car. And when asked if he had espoused these views to clients who clearly love their companion animals and who pay a lot of money for the veterinary services, he said no, because he was smart and the clients wouldn't understand. And this was based on his not wanting to absorb the expenses for emotional damages. So there is a disconnect, mostly based out of fear from the veterinary community that their expenses will skyrocket with the recognition of emotional damages. So that is where we are in the law and where some of the pushback is coming to keep damages low for companion animal deaths. Now, with respect to the veterinarians, again, most really do value animals highly. Obviously, they've gone into this field, and this is what they've made their life's work. But much like a medical doctor, veterinarians work with living beings, and mistakes can be fatal. So if the veterinary's provision of services fell below the reasonable standard of care, the veterinarian may be sued for veterinary malpractice. And depending on the requirements to prove professional malpractice in a given state, a veterinarian it may be required that a person bringing suit have the records of a veterinarian reviewed by an expert. So typically when a client seeks or questions what happened with the veterinarian, the first step is to obtain the veterinary records. And then once those records are obtained, if it appears there was a breach of the standard of care, the records can be submitted to an expert, to another veterinarian in the same field or same area of expertise, and they can be reviewed to see where breaches of the standard of care may have occurred. Now, this can be an issue with respect to the costs of the expert review. But unlike the medical malpractice cases, cost for veterinary review is actually less, expectedly so, and so it shouldn't necessarily be a bar. Additionally, there are some exceptions where a person would not be required to have an expert veterinarian review the records. This can occur with the common knowledge exceptions. Again, similar to the medical malpractice fields, amputation of the wrong leg, failure to administer oxygen. These types of things would not necessarily require an expert to review because it's clear what fault lies with the veterinarian and what actually occurred. Also know that in some situations a client may not have the money to bring a veterinary malpractice case, or it may just not be something that they're interested in, but they are concerned for what the veterinarian did, and they want to make sure that other animals are not harmed in a similar fashion. In that sense, I would assume every state has this, but I know that many states that I've encountered have in fact had regulatory reporting because the state veterinarians are licensed by state. So, for example, in Illinois, it's the Illinois Department of Professional and Financial Regulation, where a veterinarian can be reported for having committed an act such as amputating the wrong leg or failing to administer O2 during a surgery. And then that particular board can review the licensing of the vet and issue a particular punishment, whether it be a reprimand, a censure, fines, or in some cases, complete removal of a license. So that can be done in conjunction or, simply as an alternative to bringing a suit, depending on what a client may want. But just know that this type of disciplinary hearing is not something that will compensate the plaintiff in any way, shape, or form, and they may only be a part of that hearing if called to testify. Many veterinarians may work out a plea agreement or a deal with the veterinary or the disciplinary authority in place. But it is very important to make sure that the clients understand they cannot use that disciplinary route as part of as an attempt to get a settlement. So they can't go to the vet and say, well, if you don't give me my money back for this botched surgery, I'll just report you. They can't do that because that's considered a form of extortion, if you will, or something to the extent where you really cannot do that, can get your client into trouble. But they can simply report because that is an issue of public interest, a public concern, but know that they can't use that in their civil case. It only comes up on occasion, but just know that a client can never use that against a vet, but can in fact report that if necessary. Now, it's not just limited. Veterinary liability is not really limited to claims that that their conduct fell below the reasonable standard of care. In fact, other cases have involved conversion, which is in a veterinary case would be an unauthorized surgery. Say you bring your horse in for a surgery on the left leg, and they do a surgery on the right leg. That would be considered a conversion, and that is a tort that can be brought. Fraud as well. In some situations, a veterinarian who made a mistake, and which would have been treated simply as a mistake and a breach of the standard of conduct, then went on to cover that mistake up or try to hide that mistake actually occurred. In that situation, the claims can be brought for fraud. It becomes more serious because what would have normally just been a negligence action then has become something more serious. Or in some situations where a veterinarian has been unlicensed. So if they represented to persons coming into that clinic that, yes, I'm completely licensed, I can do surgeries, I can do everything a vet can do, but they can't. That is a situation of fraud, in addition to hiding mistakes from the client. Often there's also a breach of contract. And in some situations where I've seen veterinarians have attempted to put limits on liability. For example, saying to the clients who are entering, well, we're only going to give you damages of X amount of dollars, or you agree to absolve us completely of any of our wrongdoing, which has its own concerns. And most courts do not look very favorably on liability waivers where they're against public policy, because it would be any action of a veterinarian that would absolve their own negligence. And again, these are not looked upon favorably by courts. So if your clients are in fact veterinarians, I would probably not advise them to put these kinds of waivers in their agreements, because they may very well not be enforceable and in fact against public policy. It's especially true for veterinarians who may not even, who have committed a fraud, because if in getting that person to sign the contract they committed a fraud, such as saying that they had a license and they did not, there you have additional actions for fraudulent inducement. And also ordinary negligence can come up. This is actually harder to prove than, I shouldn't say harder, but because we have professional malpractice, which is also a form of professional negligence, that standard is easier to prove against a veterinarian than an ordinary negligence claim. But those can come up with respect to others perhaps at the clinic, or for something that occurred that was just completely wrong, such as amputating the wrong leg or administering the wrong dosage of medicine.